Oh, yay, oh, yay, oh, yay. This Honorable Supreme Court of Tennessee is now in session. God save the United States of America, the state of Tennessee, and this honorable court.
Good morning, ladies and gentlemen, and welcome to the June 2021 docket of the Tennessee Supreme Court. As we have done for the last many months, we are doing our docket by Zoom. We appreciate the attorneys participating. As a result of the pandemic, we have been able to utilize virtual oral arguments for a number of months now, which has been worked well to help us keep current on our dockets. Everyone, I think, of us have gotten out of our comfort zone and have become much more comfortable with this process. While it may not be quite as good as being in person for oral arguments, it does help us to continue to move the dockets and helps our justice system in Tennessee move forward. We also want to say a special welcome to those of you who are watching on our YouTube channel. Again, as a part of adapting to the pandemic issues, we began live streaming these arguments on YouTube while we do Zoom arguments. This way, it allows those folks who want to participate, who want to hear the arguments and understand a little more about our system, to see that firsthand. So we welcome those of you that are there. We hope that this is a good opportunity to learn more about the Tennessee Supreme Court and about the Tennessee judicial system as a whole. We appreciate all the attorneys being here today. In just a moment, we will begin our docket. We have two cases on our docket this morning. The first will begin momentarily. The second will begin at 10:30 a.m. Central Time this morning. When we begin the arguments, each side will have 30 minutes to present their case. And at this time, I think without any further preliminary matters, Mr. Hivner, if you will call our first case, please.
Metropolitan Government of Nashville and Davidson County et al. Versus Tennessee Department of Education et al.
Ms. Plumstein, I understand you're arguing first, and all of the lawyers for the appellants have advised Mr. Hivner as to how to divide time. Is that correct?
That's correct, Your Honor. I will have 15 minutes and the interveners 7.5 minutes each.
All right, you may proceed, Ms. Plumstein.
Well, good morning, and may it please the court. I'm Andre Blumstein. I am here this morning on behalf of the state to ask this court to uphold the constitutionality of Tennessee's Education Savings Account pilot program. At its core, this case is about enhancing educational opportunity for low-income children in Tennessee's lowest performing schools. It's about offering those children the same chance, an equal opportunity, the same chance that more privileged students have to pursue an education that best meets their particular needs. And the ESA pilot program is intended as a first step in that direction. The plaintiffs are challenging the pilot program as unconstitutional under the Home Rule Amendment. But we believe that the statute survives this constitutional challenge because the Home Rule Amendment just does not apply here. The Home Rule Amendment comes into play when three things align. There's a statute that, one, is local in effect, two, is applicable to a county, to a particular county, and three, applies to that county in its governmental capacity. That alignment just is not present here, and I will address the first two elements, that the statute is not local in effect and that the statute does not apply to any county, and the interveners will address the third element of governmental capacity. So first, the statute is, the ESA pilot program is not local in effect. It's a state program, and although it currently applies to LEAs, school districts, in only the plaintiff counties, it is capable of expansion to LEAs in other counties, which is key under the controlling precedent of Ferris versus Blanton and Civil Service Merit Board versus Burson, which affirmed Ferris. And those
Ms. Blumstein, this is Chief Justice Bivens. If I may ask a question here. How does the fact that the statute contains what's everyone refers to as a reverse severability clause, what impact does that have on your argument that it can be expanded to other counties? Because as I understand it, the impact of that clause in the statute is that if the court were to find that there is a constitutional violation here, the remedy cannot be to expand this to all 95 counties.
Well, I believe that clause could be elided from the statute to allow it to be expanded to other counties. And it does not need to be expanded to all 95 counties in order to survive this home rule challenge.
Well, General Blumstein, this is Justice Kirby. Can the Esa Act be expanded absent legislative action? Is there any way that a county can grow into it, expand into it? Does it?
No, Your Honor.
Is legislative action required?
Legislative action is required, but I
Don't our cases specifically mention that as a hallmark of legislation that is local in effect?
Yes, they do, but if Ferris versus the Ferris case is which was the first to enunciate that principle, that is, I believe, entirely distinguishable, because there in the Ferris case, there was absolutely no indication in the statute at issue that any legislative action was contemplated. Or
are you talking about the description in the ESA as a pilot program?
I am, yes, I am talking.
How is that? Tell me how that's not just window dressing, if it requires legislative action in order to expand.
Well, the provisions in the pilot program provisions are very substantive and very specific, and they require the comptroller to study the program as it was worked for 3 years and to make specific recommendations about about expansion of the program, and specifically to look at how to what other LEAs the program could be expanded using more current data. So it clearly the legislature contemplates further action if the pilot program proves successful.
General Blumstein, this is Justice Lee. The legislature did not approve additional counties for this legislation. In fact, it started with 5 counties, and the only way it could pass was to have it reduced to 2 counties. Doesn't that indicate that there really is no realistic potential for growth or to spread across the state?
I don't think so. I think that you can look at this as a compromise to implement a pilot program that's exactly what the purpose of a pilot program is, to serve as a model to show other counties that this works and is an efficacious thing.
But it could have been easily remedied if the legislature, once it got down to those 2 counties, had just put in a process for the counties to approve this program in their county, local approval, in other words. That would have fixed this whole thing, wouldn't it?
Well, on the premise that this whole thing is applicable to the counties and not to the LEAs, which is not our position.
Right. Assuming that it is, assuming that it does apply to the counties, a provision for local approval would have taken care of this issue. Do you agree?
Well, yes, if there's a finding that the home rule amendment applies.
Right.
We're not saying that if the home rule amendment applies, you still don't need a referendum.
Yeah, I understand.
General Blumstein, this is Justice Kirby again. I want to ask you about the applicable to component of the home rule amendment in this case. And it's the state's position that the ESA Act is not applicable to the counties here, right?
Correct.
Okay. Is the state is not taking the position that it's not applicable to the counties because the counties are not specifically named, right? The local education agencies are specifically named. The counties are not, but surely the state does not want a Supreme Court opinion saying that statutes are only applicable to persons or entities specifically named in them. Am I right?
That is not necessary. I think that when you are talking about the applicability of a statute, the applicability of a law, that means something more than just has some tangential effect on or takes place in.
Well, I looked at, it's not a fancy word. It's not a term of art. I just looked at the basic Black's Law Dictionary definition of applicable, and as to rules and regulations and statutes and such, it says affecting a person or a situation.
Well,
And our cases seem to adopt that. The Ferris v. Blanton case that you referenced says since 1953, it's been firmly established that any and all legislation, quote, private and local in form or effect, close quote, affecting Tennessee counties or municipalities in any capacity is void. And that language is also, the word affecting is used in the Hamilton County case, in several other cases that are home rule cases. So, so I want to explore that a little bit. And in order to do that, I need to understand the mechanism of the funding requirement, not in massive detail. I couldn't do that, but I do want to understand how it works. So do you mind if I go through that with you just a little bit? Because the mechanism is very important here.
Right. May I say a word about the affecting and apply to before we do that?
Sure.
Which is, I think that when you're talking about a law in particular, to be applicable to means that it regulates somebody or something.
All right. Well, let's look, for example, let's assume that and look, for example, at the counting requirement, which is in 49.6.2605. B1 says, for the purpose of funding calculations, each participating student must be counted in the enrollment figures for the local education agency in which the participating student resides. So if it applies, can the county, for example, ignore that requirement and say, we're not going to count the students who have left through the ESA Act and enrolled in a private school? Can the county ignore that provision?
No, the county cannot ignore that provision, but that provision, I believe, is simply a mechanism to allow the BEP funds to come in and then follow.
I'm sure that is the purpose of it, but my question is as to the mechanics. Do the counties have to conform their conduct to this provision in the ESA Act?
Yes, they do, but I don't think that requires them to do anything other than what they are currently doing.
It differentiates them, does it not, from other counties? Because other counties would not count students who had left to go to private schools in their funding formula, in their BEP funding formula.
That is true, yes.
Okay.
Ms.
Thank you.
Blumstein, General
Oh,
Blumstein,
sorry.
this is Justice Page. Let me ask you, how does the grant provisions in the ESA that will at least partially fund some of these deficits impact Justice Kirby's question?
Well, for the first 3 years, are you asking
Yes.
about the school improvement
Yes.
funds? For the first 3 years, those funds will make the counties whole, not the LEAs whole. And in fact, also, the LEAs will get to keep some of the funding because the LEAs have to pass on to the private schools only that portion of the BEP funding that is the state average. And they collect more than the state average currently. So they will, I think in some instances, it's about $4,000 per pupil that they get to keep.
May I ask Chief Justice Bivens a quick follow-up question to Justice Page's question?
Because my time has
Okay.
run out.
Yeah, sorry.
Okay.
Quick one.
Quick one, yeah.
In the course of your response to Justice Page, General Blumstein, you first said that it makes the counties whole, and then you corrected and said the local education agencies whole. You are taking the position that they are different entities. The funding comes from the county, but the school improvement grant goes to the local education agency, right? So the county funds and the local education agency gets the grant money. Am I correct?
Yes, yes, you are correct. I mean, the counties fund only partially. The state funds a majority.
Got it. But the grant money goes not to the county that provides the funding. It goes to the local education agency, right?
I'm not sure where the check goes.
Okay.
Well, but doesn't the county take into, or the city take into consideration that aspect when it passes its budget?
I'm sorry, I didn't hear the question.
Just said, doesn't the county commission or metro council, whomever it is, don't they consider that as part of the funding when they're passing their budget for the
Yes.
overall education?
Yes, of course.
Thank you. All right. Thank you, Ms. Blumstein. I think Mr. Pinger, you're next, I understand.
Good morning, Mr. Chief Justice. I'm Arif Panju, representing the parent interveners, Bogasi Diallo Natuba and Star Brumfield. We request 2 minutes for rebuttal. Your Honor, the clearest path to reversal is to reject the Court of Appeals' reliance on the so-called fiscal effects of the ESA program to satisfy the constitutional requirement that a law be applicable to the counties in their governmental capacity. This court's jurisprudence applying the Home Rule Amendment over the past 70 years puts on full display what it looks like for a law to be applicable in a governmental capacity. The law has to either act upon the form of a county government or act upon the powers of a county government. You see that in cases like Chattanooga-Hamilton County Hospital Authority, where the law empowered an entity to act on behalf of the county, exercise its power, or in cases like Ferris, where you're dealing with runoff elections. The ESA statute does none of those things. Appellant's entire case, as a result, hinges on persuading this court to treat the term applicable in a governmental capacity as requiring nothing other than showing that there's mere effects on a county. And that has no root or foundation in the text of Article 11, Section 9, Paragraph 2, and to give it no effect, the applicability requirement, and reject this mere effects theory would result in the radical expansion of the local approval requirement anytime a county thinks that something has an effect.
This is Justice Kirby. You heard my questions of General Blumstein. So I'll ask you a little bit, since you're arguing the applicability about the mechanism, the funding mechanism, if you will. Can I ask you those questions?
Yes, Your Honor.
All right, thank you. Absent the ESA Act, without the ESA Act in play, let's put that to one side and put the grant program to one side for a moment, because that goes to the LEAs and not to the county. When a county school loses students to private schools for any reason, they are not counted in the basic education program funding formula, right?
That's correct, Your Honor.
Okay, yeah, the comptroller's report says every component in the BEP depends on student enrollment. So that affects it. The ESA Act says in effect that the counties who are subject to 49.6.2605B1 are not in that situation, correct? They have to count students who go to private schools through participating in the ESA Act. Am I correct in that?
That's right, Justice Kirby. And the question for the court is whether the effect of that renders the law applicable to the county in its governmental capacity.
Well, if the counties have to conform to that, they can't say, we're going to ignore that, and we're not going to count students who have left to go to private schools.
That's right. That ministerial act.
Then how does that not affect AFF, which is the definition that our home rule cases seem to be using? How does that not affect the counties?
Well, let's assume it does affect. It doesn't render it applicable in a governmental capacity because the text says so.
Well,
there's two things.
I'm saying that Black's Law Dictionary says applicable means affecting. So if it's a synonym, I'm not understanding your argument.
Your Honor is correct that Metro reaches for dictionaries while we reached for the text of the Constitution. There are two things about the text that foreclose fiscal effects and mere effects being sufficient. The first is the usage of the words. The framers knew exactly how to use the word effect. It's a broad term. They used it in the local informer effect requirement. They did not use it in the applicability requirement. And if you just take a step back and look at the entirety of paragraph 2, the part that comes before the comma, not after the comma, which is what is at issue in this case, what comes before reflects that the framers knew precisely how to frame a provision based on the mere effects of the law. There, the General Assembly is prohibited from enacting laws that, quote, have the effect of, end quote, removing someone from local office. So they knew precisely how to do that, but they chose not to. To the extent this court has any doubt that the applicability requirement reflects an effort to rein in the scope of laws subject to local approval, and that it requires more than mere effects, the court should do what it said to do in Hooker v. Hanslem, look to the journal. On page 304 of the Journal of the Convention, you see what the resolution read, what the provision read before Delegate Pope offered his amendment that was unanimously adopted. And his amendment added the words applicable to a particular county in its governmental or proprietary capacity. Here's how the provision read at that time before that amendment was adopted. Quote, any act of the General Assembly, private or local in form or effect, shall be void and of no effect without local approval. In other words, by adding the Pope Amendment, it operated to do one thing only, to rein in the scope of laws where mere effects might have been sufficient before the Pope Amendment. It's no longer the case.
Counsel, I have a question. This is Justice Lee. In year 4 of this act, 12,500 students would be eligible for admission. Yet there is no provision for grant reimbursement at that point, which means that the county government, the county commission will have to budget additional funds to make up for that loss in grant funding. How does that not affect the county taxpayers, and the county budgetary process?
Metro and Shelby County wish they could stop counting students assigned to a school district based on the school option they pick. They simply don't have the power to do that. And whether it affects them or not, it doesn't render the law applicable to them in their governmental capacity. Paragraph 5 of the...
It's going to affect the way they govern, will it not, when they have to perhaps raise the tax rate to cover this loss in funding?
No, Your Honor, it would not. If the counties claim that they have the governmental power to pick and choose which educational options, they need to explain why their charters expressly prohibit them from controlling or administering public education, let alone deciding which educational options are available to students assigned to that district. They simply don't have the governmental.
Doesn't it deal with operations? The counties don't operate it. The local education agencies operate them, but the counties provide the funding, and that's what this appeal is about.
That's correct. And they have to show that this is applicable in a governmental capacity. But unlike core county functions, they don't set out education policy. They don't hire the people. They don't train them, and they're not responsible for delivering the education and the educational options. And if you want to look at a case where that...
I think your time's up. Let's we need to move on. Thank you. All right, Mr. Kelsey.
Thank you, Your Honors. And may it please the court, Brian Kelsey on behalf of the Greater Praise Appellants. I'd like to go back to two questions that Justice Kirby asked. The first one was about about the language or the standard that whether or not a county can grow into the program is determinative of the case law in Tennessee. And we will concede that there is some language to that effect in some of the counties, Your Honors, but adopting that position would actually require you to overturn 3 different cases that are out there: Lawler, Leach, and Bozeman, none of which follow that standard. In Lawler and Leach, that's 2 of the 3 cases in which this court has ever struck down a statute based on the Home Rule Amendment. It says in those cases, the population brackets were open-ended and they could allow other counties to grow into them. And yet this court nonetheless enjoined the laws. And then the opposite happened in Bozeman, which would also be required to be overturned because there the statute was upheld, even though the population bracket was partially closed and did not allow other counties to move into it. So plaintiff's position here would require you to overturn not only Leach, as our plain meaning position would require, but also Lawler and Bozeman. So that's why it's the wrong standard. And the second question was in regards to the funding. And there, you know, our position on the funding is exactly the same as that that was adopted by the plaintiffs in their brief. They said, quote, total appropriations remain roughly the same. That's why there's no harm to the counties in this instance.
Well,
Total
Mr. Kelsey, this is Justice Lee. What happens in year 4 and year 5?
Well, actually, so there are 2 different ways to analyze this, Justice Lee. There's looking at the counties, and then there's looking at the school districts. And so I'm speaking specifically to the counties. For the counties, in year 4, year 5, every year into infinity, total appropriations remain roughly the same. There's no change, no effect whatsoever on the counties. For the school districts, as you're referencing, they get bonus funds for the first 3 years, and then those go away in years 4 and 5. However, the Court of Appeals failed to notice that they also get bonus funds that we called in our brief remainder funds. They get those, again, for every year into infinity, because they get a remainder of $4,000 to $6,000 for every single student who leaves to go get an ESA. So there's also no harm to the school districts. However, the school districts are not before you today. They're not a party to this case, and therefore really that consideration should be irrelevant. But the counties—
Chairman Kelsey, this is Justice Kirby. I want to explore that a little bit. The accounting requirement and the funding. I'm having difficulty with your framing. Because your framing is basically that the counties are in the same financial position as they were last year. I haven't seen that framing in the Home Rule Amendment cases. The framing in the Home Rule Amendment cases seems to be, are the counties that are singled out in a different position than all the other counties in the state. So absent the ESA Act, all the other counties in the state, their local portion of the BEP funding formula diminishes, does it not, when students leave to go to a private school? Is that correct?
Your Honor, that's incorrect. Again, for these counties, there's no effect. They pay the same.
No, I'm talking about absent the ESA Act for all the other counties not affected by the ESA. I'm trying to establish what it's like without the ESA Act, and then I want to address what it's like with the ESA Act. So without the ESA Act, if a student leaves to go to a private school for any reason, that student is not counted in the counting requirement for the BEP formula. Is that correct?
That's correct, Your Honor, and that I think is the error in the position that
okay. Now with the ESA Act, Metro and Shelby counties must continue to count in their local part of the funding formula students who leave to go to a private school through participating in the ESA. Is that correct? And
here's why that's correct.
So what I'm trying to figure out is
comparison.
Okay, well, the home rule cases seem to look at how, not whether the county's better off or not better off. They look at whether they're in a different position from all the other counties in the state. So I'd like for you to address that framing.
Yes, Your Honor. And here's the key. This law does not apply to all students in private schools. So that's the incorrect comparison.
No. I said students participating in the ESA.
Exactly. It only applies to those low-income students who are already in the public school system and who the counties are already paying for or would have an obligation to pay for because they're entering kindergarten or moving to the district. So we agree with the counties that total appropriations remain roughly the same. Their problem is that they they have an ongoing obligation to pay for these students. Their problem is with these maintenance of effort statutes that have been on the books forever, that they had to pay for these students in the first place. And that's the correct comparison. They would have been paying for them but for the act, and they still have to pay for them after the act.
All of our counties have low-income students, right? And if any of them leave the county school system for any reason, then they are not counted in the county's funding obligation.
Well, Your Honor, respectfully, that's not true. For example, when they go to the ASD, they still have to pay for them. And when they go to charter schools, they still have
That's
to
a
pay
very
for them.
good
It's the
point.
same
That's a
thing.
very good point. The counties pay for students who participate in the ASD. So if they leave the ASD school through the ESA program, then the county remains obligated to pay for, to consider that student in the funding formula. Am I correct?
That's correct, Your Honor, and that's why they're in the same position
But
as
other
every
counties
county.
outside
Whether
the
they go to the
state house.
ASD or whether they go to an ESA or whether they go to a charter school, they had to pay for them before and they still have to pay for them afterward. There's no change.
Thank you, Mr. Kelsey. All right, Mr. Cooper, I understand you're the only one arguing on for the plaintiff side, correct?
To get unmuted there. Yes, Your Honor. Good morning. May it please the court, Bob Cooper, Director of Law for the Metropolitan Government of Nashville and Davidson County, arguing on behalf of the Metropolitan Government and Shelby County Government. This court should affirm the ruling below because the ESA Act falls squarely within the Home Rule Amendment to the Tennessee Constitution. It is a local bill that applies only to 2 counties, and it applies to them in their governmental capacities by subjecting them to a unique school funding formula. There is no right of local approval in the Act, and in that case, the Home Rule Amendment is clear. The Act is void and of no effect. Now, to avoid that result—
This is Justice Clark.
Yes.
Do we have to consider the standing question that's been raised before we really get to the merits of the Home Rule Charter?
Well, certainly, Your Honor. I think the two are intertwined, but let's talk about standing. Appellants argue that the counties lack standing because, as Senator Kelsey is saying, they're not harmed by the ESA Act. It doesn't place any new obligations on them. So let's start with some basics of state education law. First, school districts are required to provide eligible students with an opportunity for, quote, enrollment in a public school. The law says nothing about enrollment in a private school. This public schooling obligation is funded through the Basic Education Program, the BEP. And under the BEP program formula, the state and the counties together share the cost of K through 12 education. And this is the key point. Funding is based on the number of students attending the public schools. In fact, the statute says the formula shall be student-based, such that each student entering or exiting an LEA shall impact generated funding. Now, the ESA Act takes this general law and throws it out the window for these 2 counties. Under the Act, the state will give each student's education savings account an amount equal to the average state and local per pupil funding under the BEP. That number is about $7,600 per student, according to the comptroller. The state will then withhold that same amount, both the state and the local share, from the BEP money it would otherwise pay to the school district. So funding these accounts is not going to cost the state a dime. Instead, the Act shifts that financial burden to the counties.
Mr. Cooper, this is Justice Bivens. Let me push it. But the grant money then provided for, at least for the first 3 years in the ESA, covers that cost for the counties, does it not? And does that not cover the county's cost for the first 3 years?
The grant money, Your Honor, goes to the school district. And it may, but that does nothing to relieve the financial burden on the counties.
Well, you say it may, but is it accurate what the opposing counsel says, that Metro and Shelby agree that the total funding for education will be basically the same, at least for the first 3 years in this act.
Your Honor, the school districts will basically break even on this. But what the burden is on the counties is that these ESA students have to be continue to be counted as enrolled in this county school district for the purpose of funding calculations.
But isn't that a ministerial action?
Your Honor, it is a deviation from general state law. General state law would say under the BEP that when a student exits an LEA, the county no longer has to pay for that student. But under the ESA Act, the county has to continue to pay for that student, even though that student no longer attends a public school.
But isn't that requirement for Shelby and Davidson to continue counting those individuals a way to protect Shelby and Davidson?
Your Honor, it is a burden on Davidson. It is a burden on the counties. It is requiring them to spend more money, BEP money, than they would be required to otherwise. And it's not just with regard to current students who leave the school district to attend a private school with an ESA account. This counting requirement, this funding requirement, will apply even with regard to students who have never set foot in the county schools. That is, students who enter kindergarten with an ESA, or students who move from out of county into the county and get an ESA. The county will have to pay for them regardless of the fact that they've never been in their schools.
But I guess I'm having difficulty understanding what the additional cost to Davidson and Shelby counties are, if in fact you agree that the overall expenditures for education by both counties would remain essentially the same for at least the first 3 years.
Well, Your Honor, I think the proper comparison here is what is the obligation of the county under general law with regard to paying for students who are in their school district, and what is the obligation under the ESA Act to pay for students who are no longer in their school district.
But isn't the ESA simply creating an exception to the general law, which
exactly,
the legislature can do? Which the legislature can do.
Exactly, Your Honor. It is creating an exception to the general law and putting a unique burden on the counties. And that is what the ESA Act says you cannot do. And to go back to your question, Your Honor, about the grant funds may help the school districts, but they in no way relieve the financial burden on the counties. The counties have to fund, according to the BEP formula, for every student who is counted as enrolled. And that is an obligation that continues regardless of any grant funds that a school district may get from the state or some other source. In addition, Your Honor, the Maintenance of Effort Statute is not reduced. The county cannot reduce its funding to the school districts because of grant funds they may get, because the Maintenance of Effort Statute does not allow them to do that.
General
So the
Cooper,
grant funds provide.
This is Justice Page. I'm sorry to interrupt you, but let me ask a question here. Is there anything in this record to set forth any actual dollars as to what impact this will have on Metro and Shelby County other than this, your hypotheses?
Absolutely, Your Honor. As was noted before, in the first year of this program, there will be up to 5,000 students enrolled in this ESA program. By the fifth year, that will be up to 15,000 students. Each of those students will cost Davidson County $4,705 in extra BEP funding based on the current BEP requirement. Obviously, that number goes up as the years progress. In Shelby County, each of those students will cost Shelby County about $2,400 in BEP funding.
How do you arrive at those figures if during the first 3 years there's grant money to make up those deficits?
Because again, the grant money does not affect the statutory requirement to make a BEP payment. The grant money does not in any way change the county's statutory obligation to make BEP payments based on the number of students who are counted as enrolled in the county.
But this is
grant money
just
is irrelevant to that.
this is Justice Bivens, Mr. Cooper. The grant, technically, the grant money may go to the LEA,
Yes.
but the LEA does it not take that into consideration when it submits its proposed budget to the county legislative body? And the county legislative body then ultimately has a total appropriation to the county.
The county makes the appropriation. That is correct. And that is why this act has this significant impact on it in its governmental capacity.
But am I not correct in that when the LEA submits its proposed budget to the county, it takes into consideration those funds, and that thereby the legislative body of the county also takes that into consideration when it's making its overall appropriation?
Your Honor, again, the BEP formula is enrollment driven. So whatever the enrollment is, that is the threshold number that the county has to pay to the district. And in addition, many counties pay additional money. Shelby and Davidson both do that. And the maintenance of effort statute says that a county cannot reduce its appropriation from the previous year, except where enrollment has gone down. And the thing about the ESA statute is it keeps the enrollment from going down, even though these students have left the school district. So no, they can't make that adjustment, Your Honor.
Mr. Cooper, this is Justice Lee. The reimbursement grant is only for school improvements, is that right? Rather than incurring expenses?
That's exactly right, Your Honor.
So,
it is only for improvement, and so it can't be used as general funds, can't be substituted as general funds. And again, it is an unfunded mandate. It is subject to appropriation each year. And as has been pointed out, it ends with regard to any direct support to the school district, to these two school districts after 3 years, even if it's funded. And in the meantime, the enrollment, the size of the ESA program will continue to expand. In fact, I believe the legislative report on the financial impact of the bill indicates that the shift in BEP funding could be as much as in the tens of millions by that point.
Mr. Cooper, one follow-up question. As originally written, this Amendment 1 applied to 5 counties, Davidson, Hamilton, Knox, Madison, and Shelby counties. And in order to pass this bill, all the counties were eliminated, but Davidson and Shelby, which one legislator referred to as the deep blue metropolitan areas. If this bill had been approved either as written, Amendment 1 or Amendment 2, applying to 4 or 5 counties, do you think that the Home Rule Amendment would have been implicated in any way?
Your Honor, the bill in Amendment 1 in both chambers would apply the program, have applied the program to any LEA, I believe, with 3 or more schools in the lower 10%, ranked in the lower 10%. And that would have been on an ongoing basis. So it was a bill of general application. It was a bill that if performance of schools in those 5 counties, Davidson, Shelby, Hamilton, Knox, and Madison, had improved, they could have fallen out. If other counties that had a dip in performance had gone on that list, they would have gone into the program. That is the definition of a general bill. That is something that, as Ferris says, is potentially applicable statewide, and counties can enter and out and go out. The problem is that in order to pass the bill, not only did they have to strip out counties, so they hiked that number from 3 to 10, they also had to base it on historic data, data in the past that obviously is never going to change. So there is not a potential applicability issue here because there is no way that this act can expand absent legislative action in the future. It now and will always apply only in these 2 counties. absent something, absent a change in the law.
Thank you.
General Cooper, I want to follow up. Chief Justice Bivens was asking some good questions, and I want to make sure that I understand your answer. How does the funding work absent the ESA? And then how does it work with the ESA from the county perspective?
Right. Absent the ESA, let's say just absent the ESA, then the BEP payment made by the counties is based on enrollment. And as students enter and exit the school district, then that BEP requirement goes up or down since it is based on enrollment. So
and
if a
maintenance
student
of effort as well, the maintenance of effort component of the funding as well is
the maintenance of effort, exactly.
By enrollment. Okay.
If enrollment goes down, then the county is free to reduce its total payment for education under the maintenance.
All right. Does the county's funding obligation include ASD schools within those counties?
Your Honor, the way that ASD works is that when the state takes over a school from a school district, the state then takes also the full amount of funding that would have gone for that school, not just the BEP payments, but also any maintenance of effort, withholds that. The state withholds that from the BEP payment it would otherwise have made to the school district. So that leaves the school district in a hole. Obviously, ultimately, all of this money comes from the county.
Okay,
And so the burden falls on the county.
Not from the school district perspective, but from the county perspective, if there's an ASD school within the county, the county still has to appropriate the funds for that school.
The county is still ultimately responsible for appropriating the funds for every school in the school district.
All right. What about if a school? What about if a student who's attending an ASD school leaves for some reason, moves or goes to a private school? Okay. Does that affect the county's funding obligation?
It does. If they leave without an ESA, then they have exited the ASD school, and that lowers the obligation under the BEP to provide funding because the BEP is based on enrollment. So right. Yes, it would reduce that funding obligation.
So how does it work with the ESA in place?
With the ESA, then that student, even though the student has left for a private school, is still counted as enrolled in that ASD school, and that artificially inflates the amount of BEP payments that have to be made. Your Honor, this ESA Act, it's like the Hotel California. Students check out of the school district, but financially they never leave.
Well, what about the grant money? How does that affect the county's funding obligation and include ASD schools?
Okay. The grant money has no impact whatsoever on the county's funding obligation.
Well, Chief Justice Bivens was asking, the budget process is the county has to consult with the local education agency, right? So they sort of arrive at an agreement. Isn't the grant money given to the local education agency going to affect the budget that is ultimately appropriated by the county?
Your Honor, it can have no effect on BEP funding obligations because the BEP funding obligation is enrollment driven, and that is set by statute. So grant funding does not change that statutory obligation. Similarly, grant money does not change the maintenance of effort requirement. Even if a school district can get grant money from some source, the state or otherwise, and these are grants from the state. State law specifically prohibits counties from reducing the amount of support that they provide to their school districts based on an increase in state funding. That applies to an appropriation, that applies to a grant. So unless the enrollment drops, Maintenance of effort requires the county to appropriate at least as much this year as it did last year to its schools.
And the ESA mandates that it not be affected by a drop in enrollment, at least
because
for students who participate in the ESA, correct?
Yes, because of the counting requirement in the ESA statute, then that keeps the enrollment artificially high and prohibits the county from taking advantage of that ability to reduce its maintenance of effort.
All right, thank you.
Ms. Gerber, this is Justice Page. I want to go back to Justice Clark's question when we first started your argument about standing. I'm not sure we ever finished that. Is it your position for your client that the sole reason for standing of the counties in this case is the fiscal impact of the ESA on those counties?
Well, Your Honor, it's not just a fiscal impact. Obviously, that's important, but this requirement of funding, of counting these students as enrolled, and the impact on the funding impacts the county's taxing, budgeting, appropriation, and operational capacities. So that is, Your Honor, the definition of having an effect in a governmental capacity. And there is nothing contingent or hypothetical about this, Your Honor. Almost 700, before the injunction was put in place, almost 700 applications have already been deemed complete for an award by the state. And each one of those students will impose this burden on the counties. Each one will cost in BEP money, Davidson County, $4,700 in extra BEP funding, and Shelby County, $2,400. So we think that there is clear basis here to establish standing with regard to bringing these claims.
And if this court hypothetically were to find there's no standing, in your opinion, what happens next?
If the court finds there's no standing, then we would be disappointed, and obviously we'd go back to the trial court and argue over whether there are some other factors to take into account. But Your Honor, we think that the standing issue is pretty clear here. So
what about the McEwen plaintiffs who filed an amicus brief here? That case is still viable, correct?
That is the case by the families.
Yes.
Yes, certainly. That is being held in abeyance, Your Honor. But I mean, the point is, Your Honor, this is a home rule amendment claim. And the home rule amendment is specifically drafted by the Constitutional Convention of 1953 and approved by the voters overwhelmingly in the subsequent referendum to protect counties from local bills. This is exactly what this amendment was meant to do. And counties are, of course, the party who are affected by that, who are impacted by that. And let me go, Your Honor, and address, I guess, a couple of points that were raised before. And one is this question of what does it mean to be applicable? We would argue here, Your Honor, that the ESA Act is clearly local. And the next question is whether it's applicable to the counties in their governmental capacity. And obviously the counting requirement applies directly to the counties, so it's applicable, but it applies to them in their governmental capacity. And a county functions in a governmental capacity when it acts on behalf of the state. And when a county pays for local education, it is acting on behalf of the state. And that is what this court held in Board of Education of Memphis City Schools versus Shelby County, 1960 case, which is quoted at length in the Ferris decision. Now, the Board of Ed case involved an equal protection challenge to a private act that changed how Shelby County split its school tax revenues between the county and the city. Went from a 40-60 split to a 50-50 split. And I would point out that this private act, passed 2 years after the Home Rule Amendment was adopted, included a Home Rule Amendment provision for local approval, and both the city and the county approved this act. Now, the court in this equal protection challenge confirmed that the act involved Shelby County in its governmental capacity. because it affected the county's, quote, allocation of school money and the distribution of education funds, close quote. Now that clearly describes what the ESA Act does to appellee counties here. Now defendants still argue that the act is not applicable because it's directed at the school districts and not at them. But this court has repeatedly applied the Home Rule Amendment to legislation that was not directed at county governments, but still affected the county. This court used the Home Rule Amendment twice to reject private acts about general sessions courts, not about the county, in Lawler and Durham. And those acts, the court still said that the county was affected in its governmental capacity because the county provided for the operation of the courts. And this court applied the Home Rule Amendment to a private act about a hospital authority, not a city or a county, in Chattanooga-Hamilton County Hospital Authority. Again, the act was not applicable to the county, but because it affected the county, because it provided that the authority would be a public instrumentality of the county, it still required county approval according to this court. And so even though this act is about school districts, it still requires local approval because it affects the counties. And Your Honor, let me also touch on another issue that has been raised, that this is not affecting governmental authority because of this, because this is covered by the state's plenary authority over education. Now, it was, of course, the legislature's longstanding abuse of plenary authority that led to the 1953 Constitutional Convention. And the court rejected this very plenary authority over education argument in the small schools case from 1993, where the court said, or where the state was arguing that its legislative prerogative over school funding could not be challenged by local government. But this court forcefully disagreed and said it had a duty to determine whether the legislature has disregarded the provisions, plural, of the Tennessee Constitution. And that same duty, Your Honor, we would say applies here. The only other thing I'd like to touch on, if I could, the Greater Praise Academy appellants have argued that this court should take the approach that if a local bill applies to more than one county, then it falls outside the Home Rule Amendment. And that holding would directly overrule this court's decision in Leach and would be contrary to other cases in which the court applied the Ferris test, the potential applicability test, to bills that affected more than one county. In Bozeman and in Burson, this court applied the potentially applicable test to bills that affected 2 or more counties and upheld those bills because they were potentially applicable statewide and therefore local. In contrast, in Leach, this court struck down a bill that applied to 2 counties with no realistic potential to expand. But the court never said in any of those cases, this bill applies to 2 counties, so it must fall outside the Home Rule Amendment. And their focus is on the language applicable to a particular county to impose a 1-county rule. And Your Honor, we would suggest that that interpretation is not supported by the full language of the Home Rule Amendment, by its history, by its structure, or by its underlying values. They argue, the Greater Praise appellants, they rely heavily on a letter from a convention delegate, William Miller, to Delegate Lewis Pope, which purportedly advocated for a 1-county limit. But if you look at the convention record, you'll see that Lewis Pope, when asked point blank about whether the General Assembly could enact a bill pertaining to more than one local government without including a referendum, he said no. The Home Rule Amendment applies to all local bills, even those covering 2, 3, or more jurisdictions. And less than a page later in the journal, minutes after Pope made that statement, Delegate Miller asked Delegate Pope a series of questions about the Home Rule Amendment. It was an involved discussion between the two. And during that discussion, Miller never corrected Pope's statement about local bills covering more than one jurisdiction. On what Greater Praise says was a critical issue, Miller never said, hey, what about that letter I sent you? Miller's silence on this point is deafening and fatal to Greater Praise Academy's argument. So if the court has no other questions, I will just sum up here. In summing up, I'd like to go back to a quote from the Constitutional Convention, something that Delegate Miller told his colleagues toward the end of that convention. And he said, "Experience teaches us that the legislature cannot be depended upon to pass a law taking away from itself the power to enact local legislation. The only way it can be done is to write it into the Constitution as a restraint upon legislative power." That is exactly what the convention did, and that is exactly what the voters approved. The ESA Act demonstrates that Miller's words remain as relevant today as they were in 1953. The Act clearly exceeds the General Assembly's authority under the Home Rule Amendment, and we urge this court to affirm the Court of Appeals decision that the Act is unconstitutional. Thank you, Your Honors.
Thank you very much, Mr. Cooper. All right, on rebuttal, General Blumstein. General Blum, I believe you're muted.
You would think after all these months, I would know to do that.
Happens all the time.
We all still do that, yeah.
Yeah.
I would like to go back for a moment to the questions about standing and ripeness. Justice Page, you asked whether there was anything in the record about the dollars involved, the financial harm. And there is nothing in the record other than the the fiscal note and the legislative brief, and those which purport to guess at what the cost of all of this might be. Those are all based on speculation and hypotheticals. It is this came up on this case came up on this appeal came up on a motion for summary judgment. And it, I think, is interesting to note that in the plaintiff's Rule 56 statement of material facts, undisputed material facts, there is not one mention of any kind of financial harm whatsoever. None of these figures are in that statement.
This is a declaratory judgment action, right?
Yes.
Am I correct in that? So nobody's incurred any harm yet, right?
Nobody has incurred any harm yet, and the trial court, in fact, said that until this program has been implemented, has been up and running, there's no way to know how the math will work and what impact, if any, there will be on the plaintiffs. So that I believe underscores our ripeness argument that nothing has happened yet, and nothing can be definitive until the program has been implemented.
General Blumstein, this is Justice Clark. Let me just raise a clarifying question about the ripeness argument, because this case is here on interlocutory appeal. 2 issues only have been certified. There are a number of issues, including parties and and constitutionality of other things, still before the trial court. I understand in the trial court that you interposed a ripeness challenge to the other 2 constitutional claims, but that this is the first time you've raised the ripeness challenge with respect to the Home Rule Amendment claim. Is that really properly before us? It's not a certified issue on this interlocutory appeal.
Well, it is a threat. It was not specifically certified, but it is one of those jurisdictional threshold issues that is never waived because the court has a responsibility to consider ripeness along with standing. Those are both threshold jurisdictional issues. But it is correct. We did not raise it below. But nevertheless, it is properly before the court.
General, I have one very quick question. Under the state's theory, what person or entity would have standing to challenge the constitutionality of this statute?
A person or, let me just say that I believe, Justice Lee, that question presumes that every time somebody doesn't like something, there has to be a legal remedy, which is, of course, not the case.
Right.
But a person or entity who has actual palpable damages would be able to do that. And if
who would that be in this case, in your view?
If what the plaintiffs are saying proves to be true, if there is substantial financial harm, then theoretically they would have standing when and if that harm occurs.
Okay, thank you.
All right, thank you, Ms. Blumstein. Mr. Panju?
Thank you, Mr. Chief Justice. The problem with the fiscal effects theory is that it has no limiting principle. It is arguable that just about anything can be a fiscal effects. There's nothing in the case law, despite 70 years of jurisprudence and this court weighing in over 20 times on this question. I'd like to direct the court's attention to one of those cases decided just 6 years after the delegates unanimously approved the Delegate Pope Amendment to not only have a law be local in effect, but also be applicable in a governmental capacity. That case is Parrott v. Carter. It involves education. And not only that, it involves Carroll County, which had a relationship with the county school district, and it involves an educational option that's not the county school district, and a complaint that students will be leaving. And that's a home rule amendment problem. This court disagreed. It disagreed because special school districts, that educational option in that case, was not a county or a municipality. But if fiscal effects were sufficient, if Carroll County could simply claim the effects of that, then you'd see it in that case. It's simply not a thing, which is why Metro and Shelby County are still spending a large amount of their time in their presentation in the legislature, in the General Assembly, rather than in the text or in the case law when it comes to applicability. Applicability in a governmental capacity is a constitutional requirement. It requires that a law act upon the form of government or upon the exercise of powers. And the Miller-Pope letter explains why the delegates were concerned about this. I direct your court's attention to the entirety of the Pope letter, which Metro and Shelby refused to contend with. Here's what their concern boiled down to. By confining the language to any act concerning the powers or of a municipality or a county or the form of government, we can avoid the possibility, they can avoid the situation where a county merely saying affecting triggers local approval. There's simply no fiscal effects issue that plays any role in the applicability requirement. Doing so would render Delegate Pope's applicability amendment, which was unanimously adopted, mere surplusage. Fiscal effects is a backdoor for policy arguments, and this court should reject it. It has no foundation in the law or the text of the provision at issue in this case.
All right.
Thank you, Your Honor.
Thank you, Senator Kelsey.
Thank you, Your Honor. Just two last issues that I'd like to leave the court with. First, on funding, the grant funding for the 3 years, that does go to the issue of ripeness and not necessarily injury today, because admittedly, that does go away in 3 years. So let's just leave that aside for the present injury discussion and focus on what happens every single year in perpetuity. And General Cooper just said it, and he said counties will basically break even. So the amount of money that they spend is the exact same, regardless of whether they are a county subject to the ESA program or a county that's not subject to the ESA program. Either they pay for these students because of older statutes that have been on the books for years, requiring them to pay for all school-age children. That includes older statutes like the Achievement School District, charter schools. All school districts have to pay for those students, even though all counties do, even though they are no longer responsible for educating those students. This is the same thing. Or under this new law, the counties still have to pay for those students because of this new ESA new ESA statute. It's not a new funding requirement. And then also on the school district side of the ledger, the remainder funds of $4,000 to $6,000 remain with the school district every single year into the future. And plaintiffs admit on page 71 of their brief that those remainder funds increase their operational per pupil funding. So let's go back to the counties and we'll leave it on that on funding. Because their finances do not change at all, their only real beef with the statute is the policy decision of where these children are educated and whether or not they go to private schools. And statutorily, counties simply have no policy role in education. Their only role is one of funding, and they admitted again today, counties will basically break even. And then finally, let me just end on our primary argument in this case. This court should apply the plain meaning of the Home Rule Amendment and conclude that a particular county means only one county. In fact, the drafters modified a county with a particular county. And so there's strong language for that, supporting that in the Burson case, that it reached its decision based on it applying to 3 instead of 1. And that argument is only inconsistent with Leach, whereas the plaintiff's position would require you to overturn Leach, Lawler, and Bozeman. Thank you.
Thank you, Senator Kelsey. Counsel, thank you very much for very good arguments here today on a very difficult and a very important case. And at this point in time, we will end this particular session, and we'll be returning at 10:30 for a second case today. Mr. Hivner, if you will please recess court, please.
This honorable court is now in recess until 10:30 a.m.